As businesses prepare to open in Ontario, many workers may have questions about their return to work. What would that look like? What rights do employees have about a safe workspace? There are specifications that you need to know. Employment lawyers say that it's not that simple. And Alex Lucifero joins us now live this morning, partner with Samfiru Tumarkin LLP. Alex, good morning. Nice to see you.
Good morning, Annette.
So let's get right to it. We got a lot of questions here that I think are very important for a lot of viewers. First of all, can an employer discipline or even fire an employee if they refuse to go to work for either the reason that they don't feel safe going back because of the pandemic, or that they would prefer to remain at home collecting the CERB, which is that $2,000 a month?
Well, an employee simply can't stay home, Annette, because they feel like it. So as someone who is employed, they do have an obligation to attend work and to work. And so the reason has to be legitimate. It has to be either due to a medical condition or because they're having to care for a family member, for example, who's ill. Those kinds of situations, those kinds of examples will be deemed appropriate. My advice to those employees would be to go out and get a note from their doctor saying that they're not able to work for medical reasons, whether it's an underlying issue or again, having to care for a family member. But absent those kinds of reasons, again, an employee can't just decide, an employee rather, can't just for themselves decide, you know what, I don't feel like it, so I'm not going to attend work.
Can that person they have to care for be their kids right now? Because the kids are not going back to school anytime soon. Is that a legitimate reason if the parents have to say, look, I can't go back to my work because I don't have school or daycare for my children right now?
It's an excellent example, and absolutely they can. So an employer has a duty to accommodate an employee in the workplace on the basis of family status. So if as an employee you have an obligation to care for your children and you have no other recourse, you have no other ability to exercise daycare or have other family members care for those children, you would absolutely have the right to stay home and care for your children, and your employer would have to accommodate that.
What about, does an employer legally have the ability to return an employee to work in a different job or with modified responsibilities?
It's an interesting question because we will see different workplaces post-COVID-19. I mean, there are going to have to be some degree of changes enacted in the workplace in order to keep workplaces healthy and safe and simply in order to run your business. That said, Annette, the starting point should be an employer cannot make any kind of significant or substantial change to an employee's terms of employment. So regardless of COVID-19 or not, an employer wouldn't be allowed to change an employee's position in a significant way. So minor degrees of change are, I think, to be expected to a certain extent, but the real bulk of an employee's job duties and responsibilities are going to have to remain the same. Otherwise, that may very well be what we call a constructive dismissal, meaning that employee would be able to refuse the change and obtain a severance package instead.
Can a business recall younger employees over the more senior employees who may be closer to retirement years as a result of fears that they could be more vulnerable to COVID-19?
That is a very, very dangerous proposition, Annette. I think on its face, that would be age discrimination. You cannot make decisions in the workplace on the basis of an employee's age. Again, that would be discrimination and contrary to the Ontario Human Rights Code. And so legally, I think that is a can of worms that an employer doesn't want to open. I also think, practically speaking, that's not necessarily correct anyways. I mean, I don't think we can generalize and say all older employees are more vulnerable than all younger employees. I think we have to look at, individuals in the workplace, and a 40-year-old may very well be just as susceptible to COVID-19 or to getting sick than a 60-year-old or 65-year-old. So I think it's wrong on both counts, legally speaking, and also from a medical point.
Let's talk about how far businesses have to go to protect their employees with regards to PPE, social distancing, disinfecting surfaces. Where do they have to go? Do they have any, are there any legal ramifications for the employer if they don't? Or is it necessary that they do?
It is absolutely necessary. So employers have a legal obligation to keep their workplaces healthy and safe. Just at the end of last week, the Ontario government introduced some guidelines for lots of industries, for a number of industries, just outlining some very basic principles with respect to health and safety in the workplace in this kind of post-COVID-19 era. These are not earth-shattering methods, Annette. A lot of it was very basic stuff: hand washing, cleaning tools and office equipment, practicing social distancing or physical distancing in the workplace, and scheduling shifts in that way. And so again, these are going to be a lot of kind of common sense basic rules that employers are going to have to be enacting, and more than going to have to be, they absolutely have to enact by law. Otherwise, they are risking the health and safety of their employees, and that's a problem. An employee can refuse to work, can enact what we call a work refusal in the workplace if they do feel as though their health and safety is being put in jeopardy. And that's difficult from a legal point of view, but also difficult from a practical point of view. You want your business operating smoothly, and so as a business owner, you want to take all of the necessary and reasonable precautions you can in order to make sure that business continues as usual.
One last real quick question for you, Alex. Do employers have the right to take an employee's temperature or force them to wear a mask?
It's a hot topic, and quite frankly, our position is changing with the science. I think recently our medical professionals have told us that actually temperature taking isn't really all that accurate or helpful when determining whether an employee may have COVID-19 or may be ill. A person may be asymptomatic, but easily transmit the disease. And so we're now leaning more towards actually temperature taking not being an effective method, and employers are going to have to find another way, and that's asking employees who are ill to stay home and to self-report any kind of symptoms.
All right, employment lawyer Alex Lucifero, thank you so much for your time and answering all these questions for us today.
Pleasure as always, Annette.